Okay, after having heard this presentation by the European Commission, we will follow right now the two interventions from Italian and German competition authorities, which will give us the perspective, the national perspective from the national authorities. So I will give the floor to Andrea Pezzoli, Italian competition law, AGCM, who will talk on the policy and the practice of the Italian competition authority. Please.
Thank you, Chairman. I would like to thank Margherita Colangelo and Professor Zeno Zenkovic for the invitation. And I was asked to focus my intervention on the policy and the practice of the Italian Competition Authority. And I'll focus mainly on the enforcement side of our intervention. And I mean, reusing what Maria Teresa Maggiolino said this morning, so the quotation from Bill Kovacic about the Italian bicycle, the bicycle and the high-speed car. I will focus my intervention on the Italian bicycle. So I think that we really ran slightly fast, so I'm quite happy about the speed of our bicycle. So I'll try to argue about that. So the morning session has already widely discussed the basic ingredients of competition analysis in online market and already widely discussed even the booking case. So So I'll then skip the initial slides of my presentation because they risk repeating most of the discussion of this morning. But I mean, I think even if a brief recap could be useful, I think that something could be said about some data concerning the Italian e-commerce. I mean, not big data, which would be more consistent about the topic of this conference, but small data. Because, I mean, as Silvia has already stressed, I mean, our attitude to e-commerce is much below the European average. In fact, I mean, in e-commerce in Italy, I mean, is about 13 billion euro in 2014, smaller than in other European countries, and we have already seen it in the figures already shown by Silvia. But it grew fast in 17.5% in 2014, and individuals who made at least one purchase online in the last 12 months were in Italy just 22% in 2014, 15% in 2011, and we have to compare it with the 50% at the European level, at least the 28 European level. And only 8% of the firms receive online orders. Again, 18% is the European average. Some other data: share of sales going through .com companies increased to 54% in 2014 and 47% in 2010. And in the tourist industry, the OTAs represent nearly 70% of online hotel booking, of the online hotel booking segment in terms of sales. So I mean, it's a quite important percentage. So and if brick and mortar retail is still predominant and e-commerce is still limited in Italy, online platforms are becoming an important channel on the online purchases. I mean, on these data, we have to frame our intervention when, for instance, if in the near future we will deal with selective distribution, we have to take into account also these basic data. I mean, I can be much faster on these slides because, I mean, the difference between the different models, the wholesale model, the agency model, have been already discussed this morning. The only thing that could be interesting to stress about this slide is what, for instance, Paolo Buccirossi discussed this morning, that there are different models. So we haven't to be confined to the only model that at present is taking place in one specific industry. There is the possibility of competition based on different models, on different business models. So this is something which is interesting because, I mean, competition is not only price competition. Competition could be played also on different grounds. Another ingredient is the difference, which is quite important in the tourism industry, the difference between OTAs and online meta search engines. This was a point which was largely discussed when we had, and not only we, but other national agencies had to define the relevant market. Because, I mean, the problem was, I mean, have we to include meta search in the same relevant market, or TripAdvisor is in or out? Does it make a substantial difference? It could make it, but I mean, there is a significant difference because OTAs are based on the agency model and commission per sale, and online meta search engines are based on remuneration based on advertisement and on the number of clicks, irrespective whether a sale takes place. I mean, I don't go into details about the risk of free riding is the core of our problem. The risk of free riding is the real problem that we should have to deal with, and unfortunately, this is my personal view, we have not a full-fledged investigation, which could have been a great opportunity to assess pros and cons of MFN, of the price parity clauses. I say it unfortunately from an intellectual point of view, but from a practical point of view, as I try to argue with the other slides, I think that we have to really make a trade-off between a full-fledged investigation and timing, because, I mean, the bicycle has to run. Otherwise, I mean, the high-speed car of the innovative markets, I mean, might be far away when the decision takes place. Again, the pros and cons of platform and priority clauses. Something, I mean, the efficiencies and the risk of restrictions are quite clear at this point of the debate. Should be, at least, because, I mean, other people are much more qualified than I am. I mean, entered in details about the pros and cons of the MFN clauses. The only thing that I would like to stress is that MFN clauses may have efficiencies, potential efficiencies, both on the consumer side and on the supplier side. So the efficiencies for consumers are quite clear. There are reduction of search costs, reduction in switching costs, reduction in market power of sellers, innovation, increased transparency, fostering inter-brand competition. But I mean, we have to keep in mind, and it could be extremely useful at the end of my presentation when I'll briefly deal with the, let's say, state intervention or the potential state intervention in this sector, that, I mean, there are also benefits and efficiencies for suppliers. In a market like the Italian market, more specifically for small and medium-sized hotels, because there is a risk and cost mitigation, the creation of a safe environment in which consumers may conclude the deal, and entry and expansion of smaller suppliers, as in the morning session more than one speaker have stressed. So the incentive to invest would be substantially reduced if hotels and other OTAs could free ride on OTAs-specific investments. I mean, the risks and the competitive concerns at this point are quite clear. All that glitters is not gold. So, I mean, there are efficiencies on one side, but there are also significant risks. And again, before dealing with Booking and the Expedia case, another definition could be useful. So the difference between narrow parity clause or narrow MFN. So the MFN clause links the price and terms quoted on the online platform to those available directly on the upstream supplier's website, ensuring that the former won't be less attractive than the latter. Whereas there is the wide parity clause, where MFN clause provides for similar protection on a wider scale, aiming at ensuring that the price and terms quoted through the online platform won't be higher than the price available directly on the upstream supplier's website or any other platform, or even offline. This is the widest form of the MFN clause. So, I mean, let's come to Italy. Let's come to our experience. I have to stress that, I mean, the unit which was in charge on this case, and the head of unit who was in charge of this case, really made a terrific effort in coordinating their activity with the other national agencies. Because in May 2015, the Italian Competition Authority, I mean, following complaints by the Italian Hotels Association, opened proceeding against Booking, which is the market leader, and Expedia. It is the market leader. It was, I mean, the hypothesis of the application of 102 was a really sexy and challenging one. But it's not so easy to assess market power in these peculiar markets. I mean, in the morning session, Paolo Buccirossi spoke of some market power. It should be somewhere some market power, but when some is enough. I mean, we have a dominant test, and the dominant test is a very old-fashioned test, but we have to deal with it. In particular, the Italian Competition Authority was concerned by the price parity clauses applied by the two OTAs to their hotel partners, so we applied 101, whereby the latter would not be able to offer equal or better room rates or any other sales channels, offline and online, including other OTA platforms and hotels' own websites. So these parity clauses applied not only to prices, but also to other terms and conditions, including room availability. So that was the starting point. So the main competition concern, the theory of harm, were mainly two. So the softening of competition among OTAs and more generally among all sales channels. In particular, these parity clauses could have the potential to substantially restrict competition on the retail price and other conditions offered to final users within the OTA channel and across the other sales channels, both online and offline, direct and indirect. I mean, for example, hotels' own websites, traditional travel agencies, and so on. And on commission fees, which were requested by the OTAs to their hotel partners. In presence of parity clauses, an OTA has no incentives to offer lower fees, as these lower costs for the hotels cannot be translated in lower room rates offered on its platform to the parity obligation. But again, these are points which have already been discussed. In addition, the clauses could foreclose the market, preventing entry of new OTAs. So the foreclose hypothesis was an additional hypothesis, not the main one. I mean, the relevant product market, I mean, the market for online hotel booking services, distinct from the market for offline hotel booking services, and the geographic market. As for the geographic dimension, the market was considered national, given the Booking and Expedia, that Booking and Expedia operate with country-specific websites and differentiated their commission fees based on the national borders. Again, there was a sort of fees discrimination, and even though the phenomenon, the issue is clearly a global one, we'll see it, I mean, there are still important and significant national differences. In 2013, online hotel booking through OTAs represented nearly 70% of the online channel in terms of turnover of hotels, and something between 25 and 30% of the total online reservations. Room booking at the hotel's website represents only something between 5 and 15 of total hotel reservations. I mean, don't forget that, the specificity, the peculiarity of the Italian market is a very disaggregated market. It's not as concentrated as the French one. So again, it's something that we have to keep in mind when we will deal with the potential state intervention in this sector. Again, international cooperation, because when we launched the investigation, almost at the same time, investigations were launched in France and Sweden, whereas, there were previous cases, as we have understood this morning, in Germany and in the UK. In this coordination, the ECN was crucial because thanks to the European Competition Network and the rules of cooperation envisaged in Regulation 1/2003, the three national agencies, France, Sweden, and Italy, achieved a significant degree of cooperation and fully aligned their timely decisions. The Expedia case is still in progress, and again, we are still coordinating our activity with the other national agencies. Given the constraints, it was a really, from my point of view, a success story. It was also a success story, have to argue it, and I think it's true that because the characteristics of the commitments were, from my point of view, quite appropriate. Because during the investigation, Booking submitted commitments consisting in a significant reduction of the scope of the MFN clauses, and the revised MFN clauses will only apply to prices and other conditions publicly. Again, I have to underline this adverb, offered by the hotels through their own direct online sales channels, leaving them free to set prices and conditions on other OTAs and on their direct offline channels, as well as in the context of their loyalty programs. So even in their previous form, commitments affect competition between OTAs, competition between OTAs and direct sales, and competition between OTAs and offline channels. So we can summarize the commitments in three parts. The first part concerns price parity and the conditions parity, which refrains from requiring accommodation to enforce parity clauses on price and other conditions offered on any other OTA. Whereas commitment 2 concerns availability parity, so the rooms, and refrains from requiring accommodations to offer on Booking the same or a greater number of rooms of any type as those offered on any other OTA, or as is reserved for the accommodation itself. So the first two commitments are expected to significantly increase competition between Booking and other OTAs, and improve competition between OTAs on the level of the commission fees they request to hotels. Commitment 3 concerns offline channels, allowing accommodation to offer equal or better condition on offline channels than those offered on Booking.com, provided, was a point on which we have to discuss quite heavily with the parties, provided that these conditions are not published online or marketed online. I guess they are aimed at the general public. That was a magic phrase. If they are aimed at the general public. This commitment reflects the concern expressed during the market test that the parity clauses have the effect of restricting competition also with regards to offline sales channels. On the other side, this commitment is expected to provide hotels with the ability to use offline distribution channels in such a way to be more competitive against Booking.com and other OTAs. Finally, direct sales, and I mean the problem is the competition between the OTA and the hotel websites. The commitment number 4 refrains from restricting unpublished conditions that accommodations are able to offer, provided that these are not marketed online at the general public. Booking may prevent its hotel partners from offering better conditions if they are made available online to the general public. So that was a final achievement that, I mean, the best we could obtain, and the narrower MFN clause that we could, that we think was appropriate to to solve our competitive concerns. So the preliminary committed package at the beginning of the discussion with the parties, Booking envisaged the elimination of the parity clauses only with respect to other OTAs, excluding hotel websites. But during the market test, it was argued that the commitment, called narrow MFN clause, would have no pro-competitive effects, as it would ultimately replicate the status quo, which means that parity clauses applying to all channels. So at the end of the story, without this specific modification, I mean, the commitment couldn't be effective. On the other hand, the promotion of direct channels by hotels partly conflicts with the aim of limiting the free riding problem and protecting hotels' investments in the online platforms, which is a benefit for consumers. So, I mean, from my point of view, striking a balance between these two legitimate interests hinges on the definition of extent of the application of the parity clauses. In its final version, the parity clause has been amended so that it applies only on deals offered through their own websites to the general public at large. So, I mean, let's try to draw some conclusions. I mean, the conclusions concern 6 points. First of all, and I think that, I mean, this first slide is partially in contrast with some of the points which were raised during this morning session. I think that if competition policy has to adjust itself to the new hot issues, to the new online issues, I think that the box of tools is, I mean, by and large, appropriate. So I think that could be considered that the legal, investigative, and analytical tools at the disposal of the competition agencies allow them to deal effectively with the assessment of clauses such as parity clauses. The use of Internet is significantly changing the way in which goods and services are distributed, particularly with respect to some sectors such as the touristic services. However, the economic framework and the traditional antitrust tools are in general still valid, and the Italian Competition Authority considers that there is no need at the moment for different or special rules or approaches for online vertical conducts, since the possible anti- and pro-competitive effects are roughly the same and the existing rules are flexible enough. So intervention on vertical restraints generally raises the need to assess and balance potential anti-competitive effects and efficiencies, preserving the operator's ability to offer and develop innovative services that are available to consumers. This holds true for both price and non-price restrictions. This holds even truer in the online markets. Again, the traditional economic framework, I mean, seems to be relatively appropriate. The story is the same. The traditional economic framework for price and non-price vertical restraints fits also vertical restraints in online markets. The difference, if any, lies in how the peculiarities of different online retail activities fit with the general framework. And in particular, there are 3 points which are, I mean, old, but at the same time that are not as studied as the rest of the story, which concern the nature and the real size of externalities and free riding. I mean, in this sense, possibly a full-fledged investigation which really dealt with the size of the investments and the risks of free riding could have been let's say, a general benefit, but again, the trade-off with timing is quite important. The increasing role of price parity clauses, which now at present it is much wider than in the past, and the role of buyer power, that again is not it's not an issue which is particularly well, let's say, well governed by competition agencies. A greater understanding of the likelihood of the nature and of the real size of efficiency motivations for vertical restraints in online markets might be helpful for a better understanding of the implications of vertical restraints. I mean, I have already stressed, but I have to stress it again, because again, since I'm aware that, and I fully agree that for instance, I fully agree with what Alberto Heimler stressed this morning, and I agreed that that international coordination is crucial. I think that the business developed through online platforms are inherently global, but I mean, there are still some national peculiarities, and so there is still scope for national intervention. And let me say, given the constraints, the story was that, I mean, so we had to operate within a framework which was a national framework. I mean, coordination and communication among national competition agencies are key, and in this perspective, the coordination between France, Sweden, and Italy should be considered a success story, considering that we had to deal with topical areas where significant divergence still exists. And I think that the intervention of my German colleague will stress that some difference is still on the table. I mean, looking at the substance of the commitments, I could say that commitments were appropriate in striking a balance between preventing potential restrictions while preserving operators' ability to offer and develop innovative services. Commitments narrowed the scope of bookings parity clause, which now is limited to creating a link between the online price and terms available on the hotel's website on one hand and on bookings platform on the other, and it may be disapplied to special groups of customers to which the hotel may offer better prices or terms. So, I mean, they went from a wide to a significantly narrower MFN. Again, it may be useful to keep in mind what Bill Kovacic said about the bicycle and the high speed, because, I mean, timing is quite crucial. And I have to stress that our bicycle runs relatively fast because, I mean, the decision was taken in less than 12 months after the launch of the investigation. And timing is crucial when the competition agencies deal with innovative and rapidly changing markets. I mean, a longer period, a 5-6 year period, I mean, could be too late. Finally, I mean, beyond competition law. So something is happening beyond enforcement. I think that the Italian Competition Authority dealt with the online, how can I say, that beyond competition law towards regulation. So there is a regulation on the table. It's still a proposal. So, I mean, it is still a proposal in the so-called DL Concorrenza. I think that, I mean, when we deal with the online competition, with platform, with disruptive technology, I think there is a wide scope for, quotation mark, good regulation. Unfortunately, regulation is much more frequently asked by the incumbents in order to protect their market position, in order to prevent innovative entry, in order to prevent, let's say, the disruptive effects of the new entry. And this is not necessarily a good regulation. So I think that other enforcement tools at disposal of the state, when it has to deal with social, industrial, and economic interests, which are external to competition analysis, are absolutely legitimate. It's a legitimate political and social agenda. For instance, when you have to regulate distribution of welfare, imbalance of bargaining power. But I mean, it's much more sloppy when you when you have to achieve the same goal that could be achieved using competition law. And in this sense, in this perspective, I ask myself, does the prohibition of the all MFNs does the ban of MFN clause deals with competition goals? So the ban is not part of policies aimed at dealing with external interests, but seems to be part of an agenda which is similar to that considered by the competition authorities. I mean, speaking of the French solution and of the proposal which is included in the DL Concorrenza, it overlaps with competition goals. So it's like saying, I mean, I could do better than what it has already been achieved using a commitments decision. Does it improve the position of hotels and their customers? And I mean, you remember that there were benefits also for suppliers. And what about the risks and the costs associated with direct advertising for small and medium-sized hotels? And above all, if MFN, even in its narrow shape, is so dangerous, and I don't think it is, why does the prohibition concerns only the hotel industry? So possibly there is an answer which is a typical, let's say, industry-specific answers. I mean, to conclude, really, because I mean, I have already, not to go over time, I think that I have to stress that the Italian Competition Authority dealt with the online markets not only using the enforcement powers. As Giovanni Petruzzella said this morning, the Italian Competition Authority recently issued an opinion concerning Uber, which is a quite interesting opinion, which tried to clarify that Uber is made of two components. Somebody asked a question this morning, I don't remember, is Uber in the same market of taxis? I mean, it's not an easy question, but I have to say that the platform surely is not. There are two components. The platform is in something else, so the regulation cannot concern the platform. There are the cars, the chauffeurs, but it is a second component. So I think if you want to rerule the sectors, and possibly you need to, because there are some, let's say, regulation gap that have to be filled, but I mean, you cannot easily say that there is a direct competition between taxi drivers and, I mean, the platform as a whole. And I mean, and the Italian Competition Authority widely intervened also on the consumer protection side. I mean, with a number of important decisions regarding the e-commerce markets. But I think for those two issues, I think I would need another presentation. Thank you.